All right, let's turn our attention now to our top focus at this hour. If you're a home buyer and your money is stuck, then keep watching because this segment is for you. In fact, there are like 100 home buyers who were locked in a decade-long deal battle with Supertech builders. That's the big case that we're talking about right now. On Wednesday, the Supreme Court gave an ultimatum to Supertech almost 5 months after it had ordered demolition of the twin towers in Noida and a refund to home buyers in 2 months. After continued delay, the court said that builders must pay back home buyers by Monday or go to jail. This order serves as a silver lining, not just for buyers in this case, but to all home buyers whose money is stuck. So what next for the buyers in the Supertech case? Things that you should know, and above all, the legal remedies that you have in front of you, as you've seen in this particular case, how the home buyers coming together actually brought them to this stage where Monday is now the deadline, whereby the builder has to repay the home buyers all the money without any deductions and with interest. So that's what the Supreme Court has ordered, and this is going to be a big precedent for all such cases going in the future as well. But let's talk more about this and what really home buyers who are stuck right now can do. I've got with me at this point Advocate Shirish Deshpande, Mumbai Grahak Panchayat and consumer lawyer, and Advocate Anish Agarwal, Twin Tower buyers advocate. Both of them are joining me on the show. Thank you so much for speaking to us here. Let me start with Anish Agarwal. In terms of this particular case first, let's talk about what was the process like, the home buyers coming together, and the fact that this is the stage where we've reached, where the Supreme Court is now saying that setting this kind of an ultimatum.
Hi, good evening. Thank you. So just to clarify, I'm representing the Residents Welfare Association. This is the association of residents who were already residing there.
Right.
Two sets of buyers, one who bought the flats outside of these twin towers in the same society, and there is one set of buyers who were in the twin towers. Now, for those who are in these twin towers, the Honorable Apex Court has directed that the money has to be refunded by 31st of October 2021. That apparently Supertech has not done. And on Wednesday's hearings, the honorable judges were very angry on the builder as to why they have not refunded the money yet. They've given time till Monday. And this was in response to various contempt petitions that had been filed by various buyers of flats in these two towers. For those who are not able to get refund by directly contacting the builder, it would be advisable for them to approach the Apex Court in a contempt petition or some other petition, because otherwise there will be no other way to enforce the judgment of the court. And from the looks of it, it may not always be the case where the builder complies happily. What other thing happened in relation to the hearing on Wednesday was that the twin towers which have to be demolished by November 30th, no demolition agency has till date been appointed. So the Apex Court has asked both Noida and Supertech to expedite all the proceedings, and the agency has to be appointed as soon as possible. In that regard, Noida has been asked to file an affidavit, and apparently they will be finalizing one of the demolition agencies soon so that the process can be started.
All right. So obviously there are two aspects to this entire case at this point in time. One is repaying the home buyers, and the other is the demolition itself of the twin towers. On both fronts, there has been a huge delay, and Supreme Court clearly not willing to put up with any more delays. But in fact, Shirish Deshpande, if I can come to you here, in terms of this case, how important do you think it's going to be in setting a precedent, in telling other builders that you cannot, do things like this and get away with it?
Well, I would say that this is a landmark judgment court where, undeterred by any pressures from any corner or any top builder and all that, Supreme Court has come down heavily on Supertech and whatever money you have invested, whatever money the consumers must have notwithstanding all that thing, since there isn't illegality in the construction, the entire towers, I think 16 and 17, towers number 16 and 17, both these towers need to be just demolished and nothing short of it. It's a strong message sent by the apex court of this country that the judiciary is not going to take it lying or not be lenient towards any such unauthorized construction. This is the strong message that Supreme Court has sent, and I'm sure the builders' law have some lessons from this and mend their ways.
Yes, absolutely. In fact, Shirish Deshpande, if you can, sort of take us through what should a home buyer know in terms of the rights that a home buyer has. In this particular case, we've seen how, coming together, coordinated effort has resulted in all of this. But very often that coordination doesn't really come in, or people are not aware about their rights. What would you say are some of the main points that home buyers should be aware about when it comes to their legal rights?
One thing I would like to draw a distinction between this Supertech issue and what we are presently in the era of, in between, because this Supertech case is a pre-2016 case.
Yes.
And why I'm saying pre-2016, in 2016, we have now what is called as a RERA Act, Real Estate Regulation and Development Act, which is a sort of a welcome act and which aims to protect the interest of the home buyers. Okay, it brings in the transparency, it establishes the accountability of the developers towards the home buyers, and it protects the rights of the consumers. Now, since RERA is there, now I would say home buyers are substantially protected. But at the same time, let's not be sort of, complacent with that, okay, act is there, certain obligations of the developers are there. Now I'm protected. No way. Every home buyer needs to be vigilant about it. Each state has now the RERA authority, state RERA authority. The state RERA authority is supposed to have all the ongoing projects and the new projects. Ongoing in the sense, any project which is not complete in all respects, which hasn't got the occupation certificate, is an ongoing project, which is required to be registered with RERA. Similarly, new projects are required to be registered with RERA, and without the registration of RERA, no developer, no promoter can advertise or sell his apartments or flats in that project. So to that extent, they are protected. Secondly, while registering, the RERA authority mandates that the promoter or the developer has to produce the approved sanction plan, approved building plans. Now in Supertech case, the issue was precisely that they had the original building plans which underwent revision once, twice and thrice. Okay, and that is where the illegalities crept in connivance with the town planning authority. Now here the RERA protects you in as much as once the building plans are sanctioned, the sanction plans are disclosed on the website of the RERA. Builder is supposed to disclose that, and that is accessible to the home buyer to see that. Now, after getting the plan sanctioned, many a time it is the habit of the builders to keep on changing the things. Now, RERA section 14 says that after the building plans are sanctioned, if there is supposed to be any revision or change or alterations or modification in the building plans, which is impacting the home buyer's particular flat or the apartment, the developer is required to take a prior consent of the home buyer, number one. Number two, if the building plan is going to alter in such a way that it is going to impact all the home buyers in that project, then 2/3 of the majority of all the home buyers to whom the flats have been sold, their prior consent is required to be taken before even the plans could be revised for that. So there is a lot of obligations cast on the promoters and the developers by RERA, and hence people have to be vigilant. People have to see when you are buying the flat, you are booking the flat, first you must see whether there is a RERA registration is there or not. Then what is the period of completion? Then every quarter, RERA requires the promoters to update the progress on that. How many flats have been sold? How far the construction has come? Then there is also the escrow account. The money that buyers pay to the developer now is required to be maintained in a separate account for that project only. and 70% of that can be withdrawn only after producing the certificate from the chartered accountant and the architect of the builder, so that the money can be taken and used only for that project's construction, and it cannot be diverted the way it has been diverted in the past in so many cases, as you know.
Yes, absolutely. Extremely important points that you've mentioned there, especially the distinction about this specific case, which is a pre-2016 case, and so it does not fall under RERA. But Anish Agarwal, coming to you here, with the coming in of RERA, how much of a difference do you think it has made with regard to incidents such as this one, where home buyers' money gets stuck? How useful is RERA as a tool for home buyers?
There are two aspects to the matter. One is a pre-dispute scenario where a buyer looks to buy a flat and see what projects are good projects, what are viable projects. And the other is a kind of post-decision issue where a person, after say 4, 5, or 6 years of getting allotment done, finds himself in a position where he's not able to get possession of the flat, and the buyer is delaying time and again. Now, there are maybe lakhs of flats which have not yet been delivered in Noida as of date, and a lot of builders are going into insolvency. In relation to all these issues, RERA has not really been able to do much, because most of these issues have actually arisen. The allotments have happened in a lot of these cases before RERA even came into picture. So, although people would have a remedy to approach the real estate regulatory authority for redressal of their grievances, still, in case a builder goes insolvent, there would not be such remedy available, and everybody would have to go before the National Company Law Tribunal. With regard to what a buyer can do after he finds himself in that situation, there are currently 4 alternatives which are present. So, to that extent, all the courts have been very lenient, so to say, and have allowed buyers to approach all possible forums for redressal of their grievances. There is no bar. However, in most cases, people are not allowed to approach different forums parallelly. So, one is the Real Estate Regulatory Authority. This depends on the state as to how the authority is functioning. In certain cases, like states like Maharashtra, the RERA authority and the tribunals are functioning very actively. However, in some cases, in some states, they are not that active, and they are not that helpful to the home buyers in getting their remedy. Other option that is always available is all the consumer forums, from the District Consumer Forum to the National Consumer Disputes Redressal Commission. And depending on what the quantum of the dispute is, a buyer can choose to go there or not go there. Third option that is available with all the buyers is in relation to the National Company Law Tribunal, where a group of about 100 buyers can come together and approach the tribunal saying that this builder has not been giving possession of the flats, and because of the insolvency code, all the buyers have been made financial creditors. They can directly approach NCLT and ask for liquidation, even liquidation of the builder, which is a very strong step. But this scenario depends upon whether the buyer is very solvent, how much assets the builder has, and all these aspects. Because in case the builder doesn't have any assets as such, then such a move will not be very helpful for the home buyers. And the fourth option, which is not really taken in most cases, is filing a civil suit, because that entails a payment of a lot of court fees. Depending on what the quantum of the dispute is, what the value of the flat is, where the property is situated, and how many buyers are willing to come together, and what the cohesiveness of the group is, considering all these factors, a strategy in all cases, in the second scenario where people find themselves unable to get possession of the property, a full strategy has to be designed. And given the fact that the builders have really sought expertise in filing and contesting cases, full teams of builders are operating and appearing before various courts on a daily basis, it is very important for the buyers to come together in a scenario where the builder is not giving possession. So that is extremely important. And the last thing is that there is no
Yes.
alternative for being vigilant. One has to be vigilant. A very important point was brought over here that various things have been brought because of RERA. But just to highlight, even in the Supertech case, UP Apartments Act of 2010 was existing, and it had very similar provisions. But still, the buyer completely overlooked those provisions and still, in connivance with the authorities, went on to get sanctions without consent of the existing buyers. So there is no alternative for vigilance. One has to be vigilant, otherwise, if
Right.
somebody takes them to task, nothing can be done about it then.
Yes, absolutely. And that's the, common point between what both of you are saying in terms of the vigilance of home buyers, which, is extremely important going into any kind of a deal or any kind of a purchase as far as property is concerned. But Mr. Deshpande, one point I want to pick up on in terms of if you are in a state where you are facing this kind of a situation and RERA is, the entire process is not as active. For example, in Maharashtra, it is active, but in some states it's not. In that case, Mr. Deshpande, what happens? What are the options in front of a home buyer if they're facing this kind of a situation?
Well, these options, I think my learned friend had just now said that. In addition to that, I mean, he has said 4 alternatives. One is the RERA, then the other is the consumer courts, then the other was an NCLT under the IBC, and one more thing I think he said, that is the civil suit and all that thing, which is rather not preferred for the various reasons, including the prohibitive cost and all. In addition to that, there is one thing is also there. Whenever these are the cases where the builder has played the mischief, there is a criminal element is there. And hence, the people can also file criminal cases. And there have been instances, particularly I can share with you in Mumbai, there are a lot of cases which are filed against builders with economic offense wing. Economic offense wing is always given power to handle certain cases beyond a certain amount of a quantum of money and all that thing. So housing cases, many a time, because the cost of housing is gone considerably high. So the consumers come together, home buyers come together, and usually such cheating is there for a class of consumers, the home buyers in the entire project as such. So the home buyers come together, then definitely they can also pursue this criminal action, so that will actually force the developers to surrender and come to terms and mend his ways and give relief to the consumers. So that is an additional remedy that is available to the consumers or the home buyers.
All right, we are running out of time, but, in fact, Mr. Deshpande, if I can just very quickly come to you and then go to Anish Agarwal as well, on what would you say are, the most 2 or 3 points, if the bullet points, if you had to tell a home buyer what to watch out for when going into any kind of a deal?
First thing, as I said, at the cost of repetition, now you are already in 2022. So everything is covered under RERA. Okay, so if you are going to buy a flat, first thing, make sure that the project is duly registered with RERA. Only RERA registration is not sufficient. The home buyer must visit the website of the state RERA authority to see, because all things are downloaded there. Okay, uploaded there. Whether it is a building sanction plan, how much the project, what the project completion date is there, how many flats are sold, how many parkings are there, all these things are there. So all that one has to take care is be vigilant, as my friend has said here. I entirely agree with him. There is no substitute for vigilance. You have to be vigilant if you want to protect the money, because housing and buying house is perhaps the costliest transaction that one ever does in our life. So you have to be extremely careful, you have to be vigilant, and you have to be alert. And you have to constantly keep on visiting this website every 3 months, 4 months, 5 months, if your project is under construction and if you have paid the things. But otherwise, my advice to them is, if it is possible, as far as possible, go for a ready possession flat, so that the element of cheating, deception, any frauds is totally eliminated. Here is the flat which is ready to walk in. Here is my money, arrange for the loan and go for it. That is a safe position for the home buyers.
All right. And very quickly, final word, Anish Agarwal, anything you would like to add to that?
Yes, just two more points that I would like to add. One is that one should always look at the contracting entity, because in most cases, the marketing agency is different from the actual builder. And at the time of any dispute, these guys really take everyone to task. So they should ensure that whoever is the brand name behind the marketing, that person should be the actual contracting entity with you. Otherwise, they will just show some random contracting entity, some SPV, some special purpose vehicle, and then it becomes difficult to later on claim anything from the special purpose vehicle. The second thing is that I have seen in a lot of cases, people come where they have paid a part of the money through bank transactions and a part of money in cash. I will request everybody not to pay a single rupee to the builder in cash, because, of course, such a transaction, firstly, is illegal, and secondly, there is no record for it. So, in case of a cheating, then there is no recourse to any of that money. Only what is paid through bank transactions or in a valid transaction is relevant. So, I would suggest that we might as well pay a little more tax to the government rather than filling coffers of the builders.
All right. Thank you, both of you, so much for joining us, and with all of that important advice for all those who are looking to buy a house or who are already may be facing this kind of a situation. We're completely out of time. On that note, it's time to wrap up this edition. Thank you so much for watching. Stay tuned to Mirror Now.